Hi, everyone, and welcome to our panel discussion on the separation of powers. We have three panelists tonight, or this afternoon, and I will introduce them all at the beginning, given our virtual format. So first, we will hear from Grant Christensen, who is an associate professor of law at the University of North Dakota College of Law. He teaches courses in federal Indian law, civil procedure, jurisdiction in Indian country, and an experiential tribal clerkship and codification course. In addition to his teaching responsibilities, he is also the director of the Indian Law Certificate Program at the University of North Dakota, and he has published extensively on topics related to Indigenous peoples, Native nations, and corporate law, secured transactions, and jurisdiction. Second, we will hear from Rodger Citron, who is Associate Dean for Research and Scholarship at Touro Law Center. He's a professor of law and has served as the Touro Law Center's academic dean and the Associate Dean for Academic Development. Dean Citron's work has been published in a number of law reviews, including the Stanford Journal of Complex Litigation, the South Carolina Law Review, and the Administrative Law Review. And in addition to the articles he has published in law reviews, he is a co-author of a documentary companion to Storming the Court. Third, we will hear from Michael Vitello, Distinguished Professor of Law at the University of the Pacific School of Law. Professor Vitello is a nationally recognized expert on criminal law, sentencing policy, and marijuana law. His work on California's three strikes law has been cited by the United States Supreme Court and the California Supreme Court, and Professor Vitello is the author of 13 books and over 80 law review articles. The panelists will each speak for about 15 to 20 minutes, and at the conclusion of their remarks, we will have a dedicated question and answer time with the panelists all together. So now I will turn it over to Professor Christensen.
All right, thank you so much, Hillary. I have a quick PowerPoint, so I'm going to go ahead and pull that up here. I think that I practiced this right. So I have a quick, 10 slides, and they're mostly pictorial in order to help kind of talk through some of my comments here on Indian law during the Trump administration. So there are a couple kind of preliminary things that I do whenever talking about Indigenous peoples and that are common kind of in my field. The first is a recognition of the place of where we're speaking. And so obviously, I guess I'm coming to you virtually while I am in North Dakota, but our symposium is in Vermont. So I really appreciate the opportunity that the folks at the Vermont Law Review have given. And thank you to my panelists and to the organizers and to Hillary for having me here. I'm delighted to be here on lands that are sacred to so many Indigenous groups, large chunks of the state being part of the Abenaki Confederacy, including several bands of the Abenaki Nation that are currently recognized by the state of Vermont. I also need to take just a brief note at the beginning to talk about terminology. I found from talking in different forums over the years, I use the term Indian very often, right? It's even titled Indian Law during the Trump administration. Depending on where you grew up and where you went to school, you learned different terms to talk about Native persons, right? So Native American, Indian, Indigenous. There are good and complicated and ongoing conversations about the use of terminology, but at least in the law, we use the word Indian. It's a legally codified phrase. We talk about Indian country at 18 USC 1151, this legal place that tribes kind of inhabit, the federally recognized Indian Tribe List Act of 1994. So I'm going to use the term Indian pretty often over the course of the presentation, and it's because I'm using it in the context of its legal connotations as a legal term of art. All right, so into kind of the substance of the piece and why I fit into kind of a separation of powers piece. So the Trump administration broke so many norms of Indian law that we aren't going to possibly be able to talk about them all. But when we have an opportunity to talk about separation of powers, it's really important that tribal sovereigns get brought in, right? Even your basic con law class can sometimes overwhelm in the notion of we get so caught up in this idea of federalism, right? Of this connection of powers between the federal government and the states, that sometimes we forget that there's a third sovereign out there, right? That Indian tribes form a set of domestic dependent nations that are themselves sovereign entities and over which the United States Constitution does not apply. And so in dealing with these separate governments, the Trump administration has broken a lot of norms and rules that have been developed over the last 70, 120, 300 years. And I'll be able to talk about them in a number of different kind of patterns and areas, with hopefully without going over time. So I've set up kind of 6 areas to just very briefly cover, and if you have questions, I hope we can take some of those during the Q&A. Tribal recognition, how COVID-19 has affected some of these tribal federalism issues, reservation status and land into trust, the application of the death penalty and tribal sovereignty, the defense of treaty rights and pipelines. So I'll start talking about Indian country and tribal recognition. And so this is the only, from an Indian law perspective or from a pro-tribal perspective, the only good maybe part of the story that comes out of these slides. We have 574 federally recognized tribes today, and that's 8 more tribes than we started with at the beginning of the Trump administration. So our Indian tribes, when you become federally recognized, the U.S. Department of Interior and the United States Executive assume that kind of functional role, that recognition of a formal tribal government and that recognition of that confirmed sovereignty. Over the course of the Trump administration, 1 tribe in Virginia won federal recognition through an administrative process. 6 other Virginia tribes were recognized in 2018 as part of an overarching congressional act that President Trump signed into law. And then in 2019, as part of the Defense Appropriation Act, the Little Shell Band of Pembina Indians in Montana became our 574th federally recognized tribe. So Indian country has grown. The number of tribes have grown during the Trump administration. And that's something that surprises some people, thinking that we must know all of the tribes that we have or that's knowable, from hundreds of years ago. But there are still bands that are seeking federal recognition through administrative and legislative or political processes, and that is ongoing today. Additionally, when it comes to the extent or the growth of what we call Indian country, these lands over which tribes get to exercise their sovereignty, we had a really big case come out just at the end of the Trump administration. It was decided by the court July 9th of last summer. The McGeorge case, which comes out of Oklahoma. And there are these 5 tribes in Oklahoma. The one at issue in the case was specifically the Muskogee Nation, that have long sought that kind of recognition that they have authority over all of their land base. They went through a process called allotment at the turn of the last century, between the 1890s and the early 1900s. Their land was divided up. Individual tribal members were given parcels of land, and then other land was opened to non-Indian settlement. And so the tribes have long claimed the authority that their reservations, even though they lost some of the land base, that the entire exterior boundary of the reservation remains. And in McGirt, the Supreme Court decided that the Muskogee Nation was indeed undiminished. And so even though a large chunk of the land has now become part of the southern part of Tulsa, it sits within the exterior boundaries of an existing Muskogee Nation. And so I've highlighted, or I found an image that highlights some of the 5 tribes kind of in blue in the center here. Really, you can see the important growth of Indian country, or the amount of land that is recognized as Indian country through the McGirt decision. Technically, McGirt only dealt with the Muskogee Nation, which is just one chunk of this blue box. But the 5 nations have a shared kind of history and a shared legislative history. And local courts are already finding that other members of the 5 tribes are undiminished. And so it's likely that a good chunk of Oklahoma that was not recognized kind of universally as Indian country at the beginning of the Trump administration will be Indian country, or will be recognized as Indian country now. And that's a huge step forward for tribes that are trying to exercise their sovereign authority and their jurisdiction. And it's going to require the state of Oklahoma to make some decisions on how it ultimately wants to go ahead and deal with these now larger sovereign entities that exist or coexist with the state of Oklahoma at the same time. My next 5 slides, unfortunately, tell a more complicated story of separation of powers and of jurisdictional struggles. So it's probably not a surprise to anyone that COVID-19 has forced some big changes in the law. COVID-19 and the virus struck Native communities disproportionately badly, anywhere from 5 to 12 times the likelihood of both spread and then of complicated disease and then death rates, depending on where you are around the country. And so in order to protect themselves, a number of tribes wanted to close their exterior borders to non-Indian traffic or to non-tribal traffic, or to control who got to enter and exit their reservations. We see states doing this too, right? For a long time, the state of New York had travel warnings for individuals who would even fly in or out of the airports, right? Had mandatory quarantine, right? States set these rules up, right, in order to police themselves. Tribes have attempted to do the same thing. And in some states, governors and courts have really worked with indigenous communities in order to promote or to allow tribes to exert their sovereignty in that way. So New Mexico had a number of pueblos that closed themselves with the support of the governor and of state law enforcement in order to try to protect their local communities. The Navajo Nation was so large that it couldn't quarantine itself off, but imposed a number of travel restrictions and monitoring restrictions, and worked with, or tried to work with, Arizona, New Mexico, and Utah in the implementation of those kinds of restrictions. Unfortunately, South Dakota took a very different tact. So Oglala and Cheyenne River, who are both highlighted, right, two of the tribes in South Dakota that you can see on the little map, passed ordinances early last year in order to restrict entry to the reservation and set up checkpoints using tribal members to go ahead and kind of police the entry and exit onto their reservation communities. Now, a number of these checkpoints are set up on state highways that just happen to run through the reservation. And Governor Noem in South Dakota sent an edict out in April of last year, threatening to sue if the tribes refused to open the boundaries, saying that you couldn't restrict state citizens from using state highways to run through the reservation. And this has resulted in a standoff. Governor Noem never sued, in part because the law is on the side of the Cheyenne River and the Oglala. So the law in this sense says that an Indian tribe is allowed to go ahead and police the activity of non-Indians within their borders if doing so is necessary to protect tribal self-government or control internal relations. And one of the standards for when it is necessary is if the activity proposed will have a direct effect on the tribe's health or welfare. And there's no way that a federal court is going to say that in the midst of a pandemic that is disproportionately affecting indigenous peoples, that tribal governments lack the authority as a matter of health and welfare in order to go ahead and restrict or exclude non-members from their boundaries, to be able to control entrance and exit, even on non-member-owned land, right, as long as it's within the exterior boundaries of the reservation. So despite a lot of blustering, Governor Noem never sued the tribe. Instead, she directly intervened in the Trump administration, which is then undergoing a review of several tribal 638 contracts. So 638 contracting is a provision under the Indian Self-Determination and Educational Assistance Act that says if the federal government would ordinarily spend, say, X dollars providing law enforcement to a tribal community, that money can be given directly to the tribal government and then spent for the provision of those services. And there's nothing in the contract that suggests that if the tribe is exercising its own inherent sovereign powers, that those contracts should be reviewed. And yet both Cheyenne River and Oglala have faced the prospect of potentially losing tens of millions of dollars in contracting, and so have gone ahead and sued the Trump administration in federal court in order to ensure that those funds and those contracts are not interfered with. We're still just in the first, 4 or so weeks, 3 weeks of the Biden administration. The best of my knowledge, these lawsuits are still ongoing because there is still a pending review of the 638 contracts, although that's something that may change here with the advent of the Biden administration, in particular with the nomination of the nation's first Native, or what hopefully will be the nation's first Native Secretary of Interior, Representative Holland from New Mexico. But that violated a norm we'd never seen before, where the presidential administration attempted to interfere with the 638 contracting process because they were displeased with a political action that was taken by a sovereign decision of a tribal entity. So we also saw the Trump administration break a norm for the first time in 70 years, trying to go ahead and remove or rid the country of an Indian reservation. So we went through, or Indian law has gone through a number of different periods. Law and policy kind of changes. We went through this allotment period where we attempted to move Indians onto individual tracts of land. Then we went through a kind of a restoration period, a self-determined or sovereignty period where we ended under the Indian Reorganization Act, we ended allotment and we created tribes as sovereign governments. By the 1950s, we entered a period of termination where we attempted to end the formal relationship between tribes and the federal government. And by the 1960s, we entered the modern period of self-determination or inherent sovereignty, where we communicate with tribes again on a government-to-government basis. This in March of last year, for the very first time, the Trump administration took a position in court to go ahead and remove, essentially, or restrict reservation land that had been taken into trust for an Indian tribe. The Mashpee Wampanoag in Massachusetts and Connecticut have some reservation land that's been recognized, and they wanted to go ahead and build upon that land a tribal health facility, some tribal housing for tribal members, and to expand some of the tribe's gaming operations. And the Trump administration entered federal court in an attempt to restrict the tribe to build on what is admittedly their land. This is land that had been taken into trust, that had been formally converted into an Indian reservation. And the Trump administration entered the court to argue that the land should not have been taken into trust, to essentially undo the Indian reservation. This is a position taken by this is the first time the United States federal government has taken that position in a court filing in more than 70 years, trying to kind of essentially terminate the reservation status. They were unsuccessful, fortunately. The First Circuit required that they overturned the administrative decision in order to find that the Mashpee Wampanoag Reservation continued to remain intact and that the land continued to be in trust. This is another situation with the change of administration that I don't expect to see some large changes. But literally to threaten the existence of tribal sovereign entities was something we haven't seen from any administration in more than 70 years. The Trump administration, for the first time in history, authorized the execution of an American Indian for a crime that occurred on the reservation over the express objection of the tribe itself. So Lesmond Mitchell, who's pictured in the bottom right corner here, committed what is admittedly a heinous crime. He murdered a grandmother and her granddaughter on the Navajo on the reservation on a highway. He was picked up as a hitchhiker. When they got to the destination, he and a minor accomplice used knives in order to kill the grandmother who was driving, drove the car out off the kind of beaten path, and then killed the granddaughter, who's also pictured here, for which he was sentenced to death in a federal court. So the death sentence comes despite the Federal Death Penalty Act of 1994, part of the 1994 crime bill, which says that the United States shall not seek the death penalty for a major crime that's committed in Indian country by a tribal member without the expressed, affirmation or agreement of the individual's tribe. And the Navajo Nation have a cultural preference or a cultural standard against the death penalty, right? That there are other forms of punishment that would be used no matter how heinous the crime. And so the Navajo Nation never agreed. The administration at the time, the George W. Bush administration at the time, found a loophole in the Federal Death Penalty Act. It said that you need the tribe's permission only to find or to seek the death penalty for a major crime that uses the fact that it's on a reservation as an element of the crime. So there's this thing called the Major Crimes Act, and as an element of the Major Crimes Act, a number of things, murder, manslaughter, kidnapping, etc., are all major crimes that exist. And as an element of those offenses, if they're going to be prosecuted, they have to be done on the reservation. So instead, the Trump administration decided to seek the death penalty for the carjacking, which is not covered in the Major Crimes Act. And think about that for a minute. The death penalty for a carjacking, not for the felony murder of kidnapping, not for the felony murder assault, not for the murder itself, for the carjacking of the vehicle. And so Mitchell was sentenced to death. A number of appeals were taken, and none of the appeals were sustained on used because of this loophole that exists in the Federal Death Penalty Act. But Indian country advocates around the country, have sought the sentence to have been converted into life in prison, in part because the tribe never agreed. This is a tribal member being sentenced to death for a crime that occurs on the reservation over the objection of the tribe itself. And the Trump administration decided to schedule Mitchell for execution, and the execution was carried out in August of last year, mere months before the end of the administration, breaking a norm where the federal government has not imposed the death penalty over the objection of a tribe in more than a century. We had two cases during the Trump administration where the administration took a different position than past administrations when it comes to the role of treaty rights in the court. And I know I'm getting closer to my 20 minutes, and so I'll try to go pretty quickly. So traditionally, it's been the role of the United States through the federal government's trust responsibility to defend treaties signed with tribes at the highest court, where the actual U.S. solicitor comes in on the side of the tribe and on the side of the treaty. The federal government took a different position, right, opposing the extension of the tribe's two claimed treaty rights in a pair of 2019 cases. So we got Washington Department of Licensing versus Cougar Den, Cougar Den being the gas station that you see in the image on the screen. There is the Yakima Treaty of 1855. The treaty includes the right to travel on all public highways. And the Yakima argued that right to travel provides in it an exception from a certain motor vehicles fuel tax that the state of Washington imposed. And so it should be able to sell fuel without having to pay the tax. And in a 5-4 opinion, a kind of divided majority opinion, three justices written by a 3-judge opinion written by Justice Breyer and a 2-judge opinion written by Justice Gorsuch. But a 5-4 opinion, the court found that the treaty does indeed extend to the exclusion of Washington state tax. And then in a second treaty case, Herrera versus Wyoming, the Crow tribe have a treaty, the Treaty of 1868, which give them the right to hunt upon the unoccupied lands of the United States. And so a Crow tribal member was exercising his treaty-guaranteed right to hunt in the Little Bighorn National Forest located just across the border in the state of Wyoming. Wyoming Fish and Game picked him up and ticketed him for hunting without a license. He argued that he was hunting pursuant to his treaty-guaranteed rights. And in a 5-4 opinion, again written by the court, the right to the Little Bighorn National Forest was considered part of the unoccupied lands of the United States, and the individual was able to go ahead and exercise his treaty-guaranteed hunting rights. But again, at the judicial proceedings, the members of the Trump administration came to oppose the extension of the treaty or the application of the individual's use of their treaty rights. My very last slide here, of course, deals with the DAPL pipeline. At the end of the Obama administration, the Dakota Access Pipeline, which runs just north of the Standing Rock Sioux Reservation here in North Dakota and runs under the Missouri River, at a point that the Army Corps of Engineers moved to be south of Bismarck so that any leak of the pipeline wouldn't affect Bismarck's water supply, but instead would run directly onto the reservation and affect the tribe's water supply. At the end of the Obama administration, the pipeline's construction and completion was stopped so that an additional consultation and environmental impact study could be completed. One of the first acts of the Trump administration was to remove those orders from President Obama and to allow the Dakota Access Pipeline to be completed. It now goes ahead and runs oil under the Missouri River, right, and has for the last 3.5 years. It has already leaked on numerous occasions, although fortunately not into the Missouri River. And the tribe continues to argue in the District Court of the District of Columbia, seeking to have the pipeline suspended. That's all together. I know I'm kind of out of time, but that's my general presentation on how the separation of powers have been affected here in the context or consequences ultimately of the Trump administration, how we've broken new norms when it comes to the extension of sovereignty and the respect of sovereignty with our indigenous communities. Sorry, Hillary, I know I was over time.
So thank you. I'm Rodger Citron, and I want to thank everyone at Vermont Law School and the Vermont Law Review for putting together the symposium. It's a great topic, and I'm going to talk about one case, and I'm going to really focus in on one justice, the Chief Justice, John Roberts. I'm going to try and go PowerPoint here. Let's see how it goes. I can't seem to find it. Is it up? Yeah, if Emily, if you could pull up the slides. I'm not connecting through. So there we go. And I'll just ask you to click. First is my talk is about the Trump versus Mazars. This was one of the two subpoena cases that was decided last summer. And I'm going to talk about the Congressional subpoenas case, the Mazars case, focusing in particular on Chief Justice Roberts and looking at the case from a number of angles. So I start with Chief Justice Roberts, and I hope this isn't too much information. I've been obsessed with Chief Justice Roberts since his confirmation hearing, as you know, to become the Chief Justice of the Supreme Court. So that takes you back, I think, more than 15 years. I think he is extraordinarily able in just about every dimension that you would look for in a justice. And what I think, you know, now that we've have some sense of his track record since his appointment, I think it was in 2005, we see two sides of him, what I call the dual identity of Chief Justice Roberts. On the one hand, he is someone who is, if I can put my own remark in quotation marks, right, playing the long game, concerned about his reputation, very much concerned about the Supreme Court as an institution, very much concerned about, if you will, the integrity of the court, and I think genuinely trying to keep the court out of the political fray. You may recall famously at his confirmation hearing the idea of, right, the judge is just an umpire calling balls and strikes. And one example, the case citation you have there is the first Affordable Care Act case in which Chief Justice Roberts, if you will, crossed sides politically to give the liberal bloc the fifth vote and essentially uphold the Affordable Care Act case. That's one side of Chief Justice Roberts. The other side is that he is a committed conservative jurist. And there's a number of cases we could cite. The first example, or the example that I put on the slide, the Citizens United case, one of a number of cases in which the court under Chief Justice Roberts has limited or invalidated the regulation of campaign finance, right, furthering a certain vision of the First Amendment. So we have these two sides to Chief Justice Roberts. We turn now in the next slide to the challenge and opportunities, the challenges and opportunities for Chief Justice Roberts in the Trump era. One challenge certainly was the further politicization of the judiciary and the courts. We saw the confirmation hearings over the two justices appointed, the first two justices appointed during the Trump era, intensely politically controversial. We had, for example, Trump himself, fanning the flames, if you will, with his rhetoric about, right, attacking Obama judges, really calling into question the idea that there is one neutral judiciary by saying that really judges are political. On the other hand, it has to be said that for Chief Justice Roberts, one opportunity that came out of the Trump era was Justice Kennedy's retirement. Justice Kennedy, the swing vote, with his departure after he retired, Roberts became the swing vote. And the separation of powers cases from the 2019-20 term show this, and that's the next slide here. There were at least 4 critical separation of powers cases in the court's last term, that is to say the 2019-20 term. There were the 2 subpoena cases, one involving the congressional committees, the House committee subpoenas that I'm going to talk about in the Mazars case, and then the Vance case, that's District Attorney Cy Vance Jr. In New York City, the Manhattan DA, who also, in connection with a criminal investigation by his office, served subpoenas on the president. So these 2 cases were met with opposition by President Trump. I'm going to come back to them in a moment, but the other 2 cases I want to put on the board, if you will, for separation of powers purposes are the Daca case. I believe the case is known as Regents, but everyone refers to it as the Daca case. We had a nice discussion of it in yesterday's first panel session during the Q&A. And the other case, the Sela Law case involving the president's removal authority in connection with the Consumer Financial Protection Bureau. Pardon me. I beg your pardon. And so all of these cases raised really fundamental separation of powers questions. Let's turn to the next slide, and we'll start to dig into Mazars. Mazars truly was a case of first impression. That is to say, it's the first time that there was litigation all the way up to the Supreme Court involving a congressional subpoena for the president's financial information or records. Key point, which we'll talk about, the records sought, they were sought of Donald J. Trump, right? These didn't have to do with actions or activities taken by President Trump. Rather, these were records about private financial actions. The subpoenas sought records from a number of entities and individuals, including the president. With respect to congressional subpoenas, the court noted, historically, it gets worked out without having to be litigated. Congress and the executive branch, it's sure it can be heavily contested, but it gets negotiated and resolved without litigation. So this truly was a first. And I think that the court, in particular Chief Justice Roberts, who wrote the majority opinion, was acutely sensitive, quite aware of the novelty of the case. Another challenge of the case was that it was a direct conflict between the political branches. You had the House, through its committees, serving the subpoenas, Article 1, serving subpoenas on the president. So a clear Article 1 versus Article 2 conflict. And all this takes place in the context of the further, politicization or political pressure on the courts and the judiciary. So if I can have the next slide, please. This is just try and run through the procedural history running up to the Supreme Court of Mazars quickly. The subpoenas, 3 different House committees issued subpoenas. The Committee on Oversight and Reform served a subpoena on Mazars, an accounting firm, and they said, we want these records because we need this information to help us decide whether we need to revise or change or add to ethics in government laws. The House Financial Services Committee and the House Permanent Select Committee, they served subpoenas on 2 different banks, Deutsche Bank and Capital One. And they said, we are investigating foreign money laundering and foreign electoral interference. So we need these records in order to help us determine whether laws on those subjects need to be tightened, revised, reformed. This is a legitimate legislative investigation, and this information is legitimately sought. Trump resisted, and the way in which he resisted, I think, is very telling about the era that we're in now. He went to court. He filed suit, and he brought suit in 2 different districts in 2 different circuits. He sued Mazars in the Southern District of New York. He sued the banks in the District Court for Washington, D.C. And the argument was he was suing those who had received the subpoenas, the entities that had received subpoenas, seeking an injunction saying, you can't comply with the subpoenas. They are invalid. Trump lost in the District Court. He essentially lost in the Second Circuit and the D.C. Circuit. And the Supreme Court granted cert and consolidated these cases for oral argument. Now, if you can remember this, because I think that the cases were argued, I believe it was in April. This was early on in the pandemic. And one of the things that was fascinating was the court not only conducted oral argument, via Zoom, that is to say, not as it had prior to the pandemic before at the court itself, but did it online. And it was broadcast. You could listen in to the oral argument that day. And the cases, that is to say, this case, Mazars, now referring to the consolidated cases involving all of the subpoenas by the House committees, that was heard on the same day as the Vance case. And at the time, it's now become, how the court conducts oral argument, but there was novelty to, they would take turns and go one at a time for oral argument. Let me go to the next slide, please. And before I talk about the oral argument, just to set the stage for the oral argument, the case was novel, but it was the case that there were prior Supreme Court decisions involving subpoenas for the president's records. There's the U.S. versus Nixon case from 1974. That was in which the Supreme Court required the president in connection with a criminal investigation to comply with a grand jury subpoena. And after that, Jones versus Clinton in a civil suit in which the court said the president in a civil suit has to comply with discovery, and the suit would go forward while Clinton was in office as president. So you can see that these were the cases everyone was talking about prior to oral argument. Right on the, very close to oral argument, I can't say it was right on the eve, the Supreme Court asked a question of the parties. Is this a political question case? That is to say, should this be worked out by the political branches themselves rather than being decided by the courts? And unanimously, every set of litigants, every set of lawyers involved said, no, this is a legal dispute that requires legal resolution by the court. So let's go to the next slide, and we'll talk about the oral argument. In the article that I'm writing for the Vermont Law Review, I talk about the oral argument in some detail. Let me just highlight a few quick points here. I find Roberts' approach, and remember, he's the Chief Justice, so from the first set of questions that he asked of Trump's lawyer, who was the petitioner in the case, he asked a question which essentially said, is this just like any other case in which we have to do a balancing of the interests? And I found that fascinating because I think one of the things that Chief Justice Roberts was trying to do was lower the temperature of the case. And I saw that question as being indicative of it. And in some sense, it was a preview of where he was headed in the decision. One thing about oral argument, sometimes, as you know, the justices become advocates for a side. Other times, they ask genuinely probing questions, which seems to suggest there's an issue that they're still making their minds up about, or that they're truly curious to hear, how a party or an attorney will answer a difficult question. So as to the former, you saw, and I think in the sequence, they were very close to each other, Justice Alito and Justice Sotomayor, in a sense, Justice Alito dropped a marker, I think, for the president's lawyers by saying, what's this idea which had been raised by one of the circuit courts below? Well, the records are appropriate because they provide a case study that can help inform Congress's legislation. And Trump's lawyer hit the ball out of the park with that question about that's going too far. That doesn't show, that can't be a sufficient legislative justification given the interest of the president, that the interest the president brings as a litigant here. Justice Sotomayor quickly countered, made the case for the significance, the importance of the records, the validity of the request. Interestingly, especially when we get to the vote tally, Justices Gorsuch and Kavanaugh, the Trump appointees, cards close to the vest, probing questions, not necessarily clear from what they asked which way they seem to be leaning. Next slide, please. So the day after the oral argument, that is the day of Monday morning quarterbacking, if you will, the conventional wisdom was, this is reflected, I think, in the newspaper accounts, that reversal was expected. There just seemed to be skepticism of the position taken by the House committee, which was very strong, which essentially said, the case law here says all we need is a valid legislative purpose. We have that. We won below. Accordingly, on prior case law, we should win again now in the Supreme Court. My own view, I said it in writing, so I'm stuck with it. I predicted 5-4 reversal, that this would look like another one of these politically divided cases. And that was my thought. Yes, reversal, but a partisan in the sense of closely divided 5-4 case. Next slide, Pete, please. Right? This is why, you never bet against Tom Brady and you never bet on me. The Supreme Court's actual decision, right? This was one of the last decisions of the term. It came out the same day as the Vance case. Both were 7-2 decisions. And Mazars in particular reads as a compromise. Thomas and Alito dissent. The significance, though, right, is that Roberts has a strong block of 7, and he's taken the case out of it's just another 5-4 political case. How did the court decide the case and Chief Justice Roberts writing? Well, he said on the one hand, on the other, specifically, Congress has a valid and legitimate power to investigate. On the other hand, we have to recognize the significance that they're seeking the president's papers. So the court rejected the higher standard sought by President Trump in his lawyers. Trump actually was represented by a private lawyer, and then, of course, the Justice Department weighed in on the side of the president, on the side of Trump. And they were seeking something like a demonstrative specific need or demonstrably critical to a legislative purpose, a higher standard than what was in the case law. Rejected by the Roberts Court. No higher standard. But what you can't get in a rule, in a sense, that the president can get through adjudication. And here's what I mean by that. Chief Justice Roberts and this court in the 7-2 decision say there has to be recognition of the special separation of powers concerns raised by a demand for the president's papers. And so these are political branches. The political branches are in a conflict. There's the risk of Congress harassing the president. That's true as much as, maybe even more true, in seeking private papers of the president. So what the court did was articulate factors for consideration, for special consideration, on remand by the district court. I'm not going to read to you that quote. I can tell you that if you go to page 140, Supreme Court at 2036-37, that's the discussion of the factors or concerns or considerations that the district court has to look at in the first instance. Next slide, please. Wrap up. 4 points. there were 4 separation of powers cases that I mentioned. 2 of them were decided, the subpoena cases, by a 7-2 vote. The other 2, Daca and the removal case, decided by a 5-4 vote. I think it's very significant that Chief Justice Roberts and the court decided the subpoena cases by a 7-2 vote, not a 5-4. And in so doing, I think that one of the things that Chief Justice Roberts accomplished was, if you will, success in the long game, avoiding the political fray. Secondly, though, let's look at the other side of Roberts's identity. This I use the short game. By remanding the case, the court took the congressional subpoenas issue, right, requiring further litigation. Resolution would not be possible prior to the 2020 election. So you can interpret that as you will, but in a sense, Roberts wins, I think, on both fronts. Where are we today? Well, 2021, a new justice and a new president. The congressional subpoenas case, Mazars, as far as I know, it's essentially stalled. And I don't know whether it will go forward. That's the last information that I could find, is that there is a stay in effect. And of course, we have a new president, President Biden, and we also have a new justice. So that while Roberts had this extraordinary separation of powers term, writing all 4 separation of powers cases, that was due in part because he was the swing vote, right? In the 2 5-4 cases, he was the 5. But of course, it's not clear who the swing vote is now, because the 3rd justice Trump appointed has changed the composition of a court that means where the center is now up for grabs, right? Justice Comey Barrett, we're not sure where the center is. So thank you.
Okay. So let me start. So first of all, I want to give a shout out to the Symposium editors, Kelsey and Caitlin. Who would have known a year or so ago when they started putting the Symposium together that every major newspaper in the country would have topics related to the Symposium on the front page on a regular basis? So I think they must be clairvoyant. Let me move to my main topic with a couple of quick observations at the outset. I have to paint with a very broad brush in the interest of time. So please follow up. You can email me. You can find me easily enough online if you have questions about any of the particulars in this paper, which keeps evolving because of the quickly changing political nature of our times. So I want to start out with this thought, and in a way, it's the overarching theme of my remarks. The Trump legacy. So you heard a deep sigh of relief among many, many millions of Americans when Biden and Harris were inaugurated. And the question I'm going to explore is, are our democratic institutions saved by the transfer of power? To get at that point, I want to compare 2 different narratives about the Trump legacy. And they're 2 completely different visions about Trump's relationship to the Republican Party. One, there are many prominent Republicans reflected in organizations like the Lincoln Project and others who really saw Trump as an aberration and repeatedly talked about his abandonment of Republican principles and norms. And for that group, the 2020 election gets us back on track. Our democratic institutions survived, and we can move forward from Trump. That's one vision. The second vision is different, and it says that really Trump and the policy positions that he took follow the long arc of the Republican Party, that indeed he advanced the major policy positions that the Republicans have been pushing now for many decades. There is some truth in both of those visions, I happen to believe that the latter vision is closer to the truth, and I'm going to explore why in a little bit. The first thing I want to talk about, though, when we're thinking about whether Trump is different from Republicans over the past several decades, I want to talk about race. Clearly, Trump's adherence, encouragement of white supremacists, neo-Nazis, and the like is truly shocking, and one would hope that the vast majority of Americans would oppose it. In one sense, he is overt in his racist views, but the Republicans cannot fully disown some of their own racist past. Go back to 1961, when Barry Goldwater said famously, quote unquote, we're going to lose the Negro vote. We might as well go hunting for other ducks, i.e., disaffected whites, many white working class Southerners, for example, and elsewhere around the country. Richard Nixon, the dog whistle of the 1968 presidential election, law and order, he was able to use the dog whistle to outflank George Wallace on his right. Ronald Reagan, the standard bearer for the Republican Party, I hope some of you realize where he started his 1980 presidential campaign at the Neshoba County Fair. And for those of you who don't know Mississippi geography, that's where Philadelphia, Mississippi is, where the 3 civil rights workers were killed in 1964. That was not an accident, nor was his use of terms like welfare queens and crack babies. Even Mitt Romney, compare him to his dad, George Romney, prominent quote unquote liberal Republican, back when that was a meaningful term, was a progressive on race. Mitt, by comparison, in 2012, when he was running for presidential, to become president, used the famous 40% of us are lazy moochers dependent on the federal government. Again, it was a dog whistle on the race question. So yes, Trump is more extreme, but the Republican parties need to own their own dog whistle appeals on the race question. So let me go to the sigh of relief theme, and whether in fact the 2020 election really is a moment to celebrate our institutions, that our democracy is secure again. First, you have to recognize the reality that the Republican Party is a distinct minority party, but it has oversized control in the government. For example, between 2016 and 2018, it had control of all 3 branches of government. It is a distinct minority party, aging whites, and there's huge support from extremely wealthy donors. As George W. Bush famously said, here we have the haves and have-mores. That's how some people think of you. I think of you as my base. Now, we know why this distinct minority party has oversized influence in the federal government, at least a couple of reasons. One is obviously the Electoral College, the unholy compromise to create the nation, giving small states each 2 senators. Combine that with the filibuster and cloture process that gives a super minority the ability to control policy legislation in the Senate, gives the distinct minority party an awful lot of control. But I want to address something else that is taking place right in front of us, but that many people simply don't see. And that's a familiar trope. And the trope works this way. The Republican Party has moved to the right. That is demonstrably true. But the other part of the trope is that the Democratic Party has moved far to the left. Now, what's important about the trope is that many independent voters buy into that trope. In fact, you can hear in the debate now going on the front page of newspapers and on NPR and elsewhere, the discussion of the lack of a center in the United States. And this trope plays into the view that there is no center anymore. so many independents. I talk to independent friends who are not all that political, and they say, you know, a pox on both their houses. Either I'm not going to vote, or I can vote Democrat or Republican. It's really not going to make that much difference because, after all, I would be endorsing somebody's extreme political positions. Well, that ain't true, ladies and gentlemen. The evidence that, here, I'll use two words to show you that the Democratic Party has not moved far to the left. Joe Biden. Now, what I want to do in the next segment of the paper to establish my point in a more analytical way, I'm going to be making reference to major policy positions of the Democrats and the Republicans. And I'm going to talk about two aspects. One, what the Republican position has been, not just Trump, but how Trump has, in effect, has advanced the Republican position as it has been in place for many years. And then the other point I want to make in considering each of these issues is to show you how, based on public opinion survey polls, and not just one or two, but many different polls, then in point of fact, the Democratic position has broad majoritarian support and the Republican position does not. So I want to start with two pieces of low-hanging fruit. The first is abortion. Now, think back to 1973 when the court decided Roe versus Wade. Most of the Republican justices on the court voted to find a woman's right to choose. 4 out of the 5 Republican justices supported it. Beginning in 1980, though, when Ronald Reagan tapped into the white evangelical vote, every Republican president or candidate for president has adopted the strong pro-life position. Obviously, by comparison, the Democrats have not. Now, keep in mind that every Republican president promised to appoint justices who are going to overrule Roe versus Wade. Well, Donald Trump may have succeeded in doing that. We may be at the point where Roe, in fact, will be overruled. Now, when you turn to public opinion polls, the overwhelming percentages of Americans support Roe versus Wade. Depending on how you ask the question, up to 77% of Americans do not want to see Roe versus Wade overruled. The second piece of low-hanging fruit, gun rights. There was a brief moment when Donald Trump was going to propose some kind of limitation on gun rights. Then he got the message from the NRA. It is the litmus test of the Republican Party to protect gun rights. No, the Democrats are not going to take away your guns, but they do propose various kinds of limitations on gun rights. And when you compare public opinion polls, the overwhelming percentage of Americans support the Democratic position. What about tax cuts? You know, you might remember when Republicans, they're starting to become deficit hawks again. But then you'll notice that they only become deficit hawks during Democratic administrations. Trump's tax policy is consistent with the long arc of the Republican Party. Income inequality, really, you can trace it back to the beginning of the Reagan administration. And the tax cuts that have largely benefited the very top percentage of income earners are really the stuff of the Republican Party. Basically, it's their cure for any kind of economic ill, despite the data that say they do not pay for themselves. Hence, the Trump position, again, entirely consistent with the long arc of the Republican Party. Well, what about voter support for it? Well, again, Americans, the vast majority, are concerned about income inequality, and they, by and large, have opposed the tax cuts of the Trump administration, the George W. Bush administration. Depending on which survey you look at, 25 to 36% of Americans supported the Trump tax cuts. The war on science. Trump, for example, came to California and Gavin Newsom, our governor, tried to get Trump to recognize man-made climate change. Trump said, well, I don't think science knows. Well, science does know. He worked hard to gut the EPA, to suppress science, to get reports that supported his view of the, I hate to call it science. Yes, Republicans early on supported the EPA. Remember, it was during the Nixon administration when the first EPA statute was passed. But those days are long gone. In fact, you go back to the Reagan administration and the George W. Bush administration when they both ratcheted up the war on science. And by the way, the EPA. Guess what? When you turn to popular sentiment, the overwhelming percentage of Americans support the EPA. They support the recognition that climate change is man-made. They support a strong environmental protection policy, again, out of phase with the Republican Party. Healthcare, ditto. Early studies suggested that the Obamacare did not have broad support among Americans. You got to dissect those studies, though, because many of the people who were disaffected with Obamacare wanted a more vigorous, less market-based healthcare system. But again, on that issue, you can see what the Republicans promised and have not been able to produce. They were going to kill Obamacare over and over again and were unable to do so. But today, if you look at the public opinion surveys, again, the Democratic advancement of healthcare for all, much closer to majoritarian sentiment. Now, why is it so premature to be giving that sigh of relief? Let me turn now to the battle that was won by, not just by Trump, but by Mitch McConnell, and that is the control of the federal judiciary. And the far right has won that battle. Mitch McConnell's bragged about how he frustrated Obama's efforts to appoint federal judges. That is well documented. I'm not making an endorsement of the filibuster. We know its destructive aspects and frustrating civil rights legislation for many years. But there was one way in which abandoning the filibuster actually pushed the Supreme Court to the right. Had the filibuster been a threat during Gorsuch, Kavanaugh, and Barrett's process, Trump might have had to have considered nominating a more centrist justice, a less extreme right-wing libertarian justice. What's less known, because again, many Americans recognize the problem with the filibuster and that debate, less well known is the blue slip process, another political norm that the Republicans have been willing to abandon to advance their position of moving the judiciary far to the right. The way the blue slip process worked was that a senator from a state where a federal judge, or someone was being nominated for a federal judgeship, could, in a sense, veto or at least slow down the process of getting that judge appointed to the court by not filing the blue slip. That, in fact, was abandoned by the Republican Congress, by Republican Senate, and by Trump. And we know what the result was, that the federal judiciary has been pushed far to the right, consistent with the Federalist Society agenda. The nominees that have succeeded to get on the court are among the most right-wing, and I don't use the term conservative. I mean, there's a difference between the far right-wing libertarian wing of the party and the conservative wing of the party. And what we now have is an extremely right-wing federal judiciary. Some of the people who are appointed to the court would refuse to confirm that Brown versus Board of Education was correctly decided. We end up with a federal court system now as far to the right as the one during the Lochner era and during the FDR years, at the point where he had to propose the court packing scheme in 1936. Now, how does this federal court, the new right-wing federal court, help it keep in place this far right-wing political party that is a distinct minority? We can debate it later, but Citizens United, I'll just say that. You can fill in the blanks. Less well known is the Janus case, a rather unusual First Amendment case, an idea, a First Amendment argument that was first advanced by members of the Federalist Society, but that there is a First Amendment right of public service union members to refuse to pay union dues for collective bargaining, even though they get all the benefits of collective bargaining. And this is a little bit of a whopper theory in my mind. But notice also the effect is that unions tend to be Democratic, not Republican. And so the Janus case starts to help erode Democratic power. The biggest problem, of course, is the Voting Rights Act. 1965 Voting Rights Act, suddenly we discover that core provisions of the act are unconstitutional. Now, I am not a constitutional law scholar. I've studied the Constitution a few times in the past 45 or so years. I don't recognize the sovereignty theory in Holder versus Shelby County, but a slim majority of the court managed to find that this statute that had been reenacted by overwhelming percentages of Congress was somehow unconstitutional. Guess what? After Holder versus Shelby County, the Republicans went into hyperdrive in finding ways to try to suppress the vote. A quick read of Stacey Abrams' book would be a good place to start if you want to see some evidence of voter suppression. But it has become epidemic. And indeed, right after the 2020 election, you know that Arizona and Georgia tipped the Senate back barely to Democratic control. But those legislatures, both controlled by Republicans, are now studying quote unquote reforms of voting, i.e., ways to suppress the vote. An area where the court has refused to act, but again in ways that favor this distinct minority party, is the refusal to take up partisan gerrymandering. It's a real risk for the 2022 election because many of the state houses are now controlled by Republican legislatures, and reapportionment of the districts may tip Congress, or at least the House rather, back to the Republican Party. So back to my final point is by way of conclusion, back to my metaphor about whether we should be breathing a sigh of relief that the 2020 election really reestablished the strength of our democracy. After all, we survived, we're still alive, we're still standing, and there's a chance to restore our democracy. Well, I'm not an optimist, and I'll share a couple of very brief parting points. One, there was a huge voter turnout because of Trump's extremism. I would propose that had we not had COVID-19 and we still had a strong economy, that Trump probably would win. And keep in the second reason to be terribly distrustful of the future of our democracy. Biden won by about 7 million votes, and yet as Larry Tribe points out, that really it came down to 43,000 votes in the three contested states, Arizona, Wisconsin, and Georgia. With that kind of electoral college vote, where the popular vote could be so overwhelmingly in favor of the Democratic candidate, and the electoral college vote so easily could have tipped in favor of a right-wing extremist Republican candidate, makes me very cautious about the future of our democratic institutions. Thank you.
Thanks so much to all of you. Those were fantastic talks. And now we have a little bit of time to have some questions which have been submitted from the audience members. So the first question is for Dean Citron. So this is regarding the Supreme Court's approach to the separation of powers. Do you foresee this court revisiting Chevron deference and the non-delegation doctrine? And if so, how?
Great question. A little bit beyond the scope of my talk, but that objection doesn't hold in an academic panel session. I can say that I think the delegation doctrine, because I asked this on my administrative law exam last year, I think it was Kavanaugh. I think it was Justice Kavanaugh and or Justice Gorsuch. That is, in separate times, they've sort of indicated we're open to considering a delegation type challenge. And now this is where Justice Barrett really could be the swing vote. Although it also could be Justice Alito on the delegation doctrine. So I started teaching in 2004. I litigated at the FCC, among other places, before becoming a law professor. Until very recently, we would have thought that this was entirely resolved by Justice Scalia in the Whitman case, or I think it's called American Trucking, which said that this is all settled by the New Deal. So it's really hard to predict for someone of my age, if I can say something like that. That is to say, graduating law school in '92, litigating for the federal government for nearly a decade after that. It's really extraordinary to see the delegation doctrine on the table. It is on the table. Chevron, much more complicated, I think, but also much more, I think, clearly on the table. And it's a little bit, I think that Professor Vitello, Mike was saying, that in the same way that we're having this question about abortion, that is to say, has the time finally come through all of these appointees? I think there's a similar question about Chevron. I think the votes are there to reconsider it. But there may be institutional reasons for the court to leave it alone. It does make their job easier, I think. So those are my thoughts.
Great, thank you. There's a question for Professor Christensen. What legal avenues does a president have to impact Indian sovereignty and policy?
Yeah, so I mean,
You have
on the
2
travel
minutes.
side, yeah, okay, yeah, I'm long-winded. Okay,
No, I'm just
no, it's good. So the president is vested with all kinds of powers, right? So from the recognition or the executive agencies, right? Essentially, kind of, if it's more than just a presidency, right? It's the executive, but the executive branch does a lot of kind of tribal relations. So from expanding the amount of land in Indian country to recognizing new tribal governments at one point it was negotiating more treaties, but Congress attempted to end treaty making back in 1871. And so now we do agreements, which go ahead and put into place they're the same thing. They're just approved by the House and the Senate that go ahead and change kind of jurisdictional boundaries. So we see, with the change in the administration, the ability to substantially grow the amount of land that is in Indian country. President Obama grew reservations by 500,000 acres, or more than 500,000 acres over the course of his 8 years. We also see administrative decisions that are taken. The Bureau of Indian Health, the Indian Health Service, the Bureau of Indian Affairs, all of these executive agencies that run or that day-to-day operations in Indian country. And so from everything from approving tribal gaming licenses to reviewing agreements for the leasing of oil and gas, to entering into settlements instead of prolonged litigation that result in billions of dollars in transfer in recognition of past wrongs with Native peoples. The presidency can really change the tone in that regard. And it's in some ways easier to undo some of the stuff administratively from my talk than from either of my co-panelists, right? The court did not move as anti-Indian as maybe it moved anti-structural, in part because Justice Gorsuch has really become quite a pro-Indian justice. Growing up in the 10th Circuit, he may have conservative attitudes about a lot of things, but he wrote both of the 5-4 opinions that I talked about just in the job talk or job talk. Wow, that's really not what this is, right? In the presentation, and that makes a big difference, right? In and of itself, his ability to switching out Justice Scalia for Justice Gorsuch has potentially been good for Indians at the court in a way that changing President Trump for President Biden will be good for Indians politically.
Great, thank you. So then, Professor Vitello, considering how the court recently ruled that challenges to political gerrymandering are non-justiciable political questions, how can we best address this one particular cause of the oversized influence of the Republican Party?
Well, yeah. I'm not optimistic. Well, here's actually, let me toss out 2 or 3 things. First, I am very worried about the future. Very much so. I remember when Trump was elected, my then 94-year-old mother-in-law fell back into her chair and said, "This is the end of American democracy." She's still alive. She's happy with the results. By the way, she's a Mississippian who is a little bit to the left of me. She's a bit of a civil rights icon. But I think our democracy really is at risk, and I don't see any easy way out. The failure of the Democrats to get control of state houses in enough states is really an ongoing problem with the gerrymandering problem. I think we need more Stacey Abrams. You need to clone her in every jurisdiction. But again, my point in part is consistent with the question that the failure of the court to take on the clear partisan gerrymandering does continue to create this risk shifting to the far right political power. And because when you look at some of the states where the gerrymander has taken place, it's quite overwhelming, like North Carolina. Sure, Maryland is a Democratic state where it's gone the other way. But when you actually look at the way it'll work out on a national map, there are more Republican-controlled states that can tip the House. I mean, each time we have elections, like for the total number of people voting in for senators, you have overwhelming numbers of Democrats, much greater numbers voting for Democratic candidates than total votes for Republicans. But the way in which the election map works out, our democracy is at risk. And because we don't have a conservative Republican Party. By the way, I mean, we have to be very careful. I respect a true conservative. We're talking about Edmund Burke, somebody who believed in good government, but small government. That's not what we have anymore. So I wish I had a more optimistic solution. I wish I had a better answer for my now 98-year-old mother-in-law, how we're going to save democracy. But my best is that we make Stacey Abrams king or queen, whatever. And we worship her. I don't mean that entirely seriously, because I'm agnostic about many things.
Great. And then there's a question for all of the panelists. So maybe if we could, you could each maybe take a turn in answering just the general question about how, maybe from each of your perspectives, how the Trump administration has either upset the separation of powers by assuming too much executive authority that hasn't been checked effectively by the other branches, or if you think that the actions of the Trump administration haven't really impacted the separation of powers, and that it's a more lasting, enduring principle in the Constitution. I'd be curious to hear your thoughts on that. So maybe Grant, do you want to start?
Yeah. Well, and so again, as the Indian law person, but not a con law person, I'll limit my response to the separation of powers with our third sovereign, right, with tribes. And in that regard, I think that the damage is past, right? That a change of presidential administration with new leaders at BIA and at Interior, at Indian Health, and a renewed commitment from the executive to meet with tribal leaders is enough to kind of undo the damage that was, risked by the administration. And again, piggyback on my comment from a moment ago, that potentially, judicial recognition of tribal sovereignty is even in a more stable place by replacing Justice Scalia with Justice Gorsuch. Of course, Justice Coney Barrett is an unknown, right? In that regard, we have 2 Indian law cases before the case this term. There's an average of 3 cases a year, and so we'll find out pretty soon. But I think, structurally, the tribal sovereign is going to have survived most of these challenges. The bigger separation of powers questions I will leave to those that study con law a little bit more in depth.
I'm going to largely defer to Rodger too. One of the interesting areas would have been the sort of unitary executive position that was advanced back in the Bush-Cheney administration and then Bill Barr. But I suspect that will not be advanced and certainly not be supported by this court, given who's sitting in the White House. But I'll defer to Rodger.
Yeah, and focusing on the separation of powers cases, I guess that's my first focus or thought. The Daca case is really a fascinating case. If you go and read the oral argument, the transcript of the oral argument, there's a real debate going on in that case, which comes down to why does administrative law matter? And there's a fabulous exchange between a number of the justices, certainly Justice Kavanaugh, and the then California Solicitor General arguing the case on this subject. And I think that administrative law under the Roberts Court is alive and well. I point to the Daca case. I point to the census case. Procedure or process matters to the Roberts Court. We can't just, rubber stamp the executive branch or political preferences. So that would be, I think, the glass half full. On the other hand, the other case, SELA law, that strengthens the president's removal power. And the blueprint for that decision comes out of Justice Kavanaugh's DC Circuit decision in the Free Enterprise case, in which there is great concern for presidential power. So in that dimension, the Roberts Court is supportive of the president's powers in that context. The last thing I wanted to talk about or note, impeachment, because we had 2 impeachments, and one of the things that really sort of was called, that the Trump administration sort of renewed attention on, was the idea of impeachment as an accountability mechanism. It's cumbersome, it's time consuming, and yet, it happened twice. And in some ways, none of the votes were surprising, but it's still fairly extraordinary. And I think one of the open questions, given some of the political dynamics that Professor Vitello talked about, is impeachment in some way becoming normalized in our political framework? And so that could be, in some ways, a product of the Trump administration and separation of powers. That is, in looking about how those two connect.
Okay, and then I have one more question for Professor Vitello. The question is, would you advocate for the Democrats employing the same tactics to get judges onto the federal courts that the Trump administration used? And if not, do you think going back to the status quo beforehand is sufficient?
I love the question. First of all, let me say that now that the Democrats led to the getting rid of the filibuster for lower federal court judges, I think that the Biden administration ought to be doing what the Trump administration and the Bush administrations did, finding very young people to put on the bench and to move them to the left. I mean, it's been a long time. I mean, Rodger, you said the liberals on the court. I don't consider the quote unquote liberals on the court to be very liberal. And I don't consider the conservatives. The conservatives are far right libertarians. So I would urge that Biden find young, very capable, very diverse, did I mention very young, and more radical judges to appoint to the lower courts. I'm nervous, and I happily haven't had to. Now I'm a little embarrassed because I'm going to go on record on the court packing. I'm very nervous about packing the court. One of the thoughts that it's not a fully formed idea, because I'm only beginning to think about this, is I think that the Congress ought to increase the number of lower federal court judges, to appoint as many possible and to create more judgeships so that you'd have more balance on the court. And the Supreme Court takes relatively few cases. And sometimes the Supreme Court is influenced by what happens among the lower courts. So I don't expect any radical transformation of anybody on the Supreme Court, but at least they would start to see if you had more good ideas coming from liberal-leaning judges on lower courts, it might kind of counterbalance. I'm very nervous, though, about the idea of court packing. It blew up in FDR's face in 1936. And, I just don't think, it's too open, raw exercise of power just to increase the size of the court. So make noises about it, maybe try to influence somebody on the court to become more centrist. But, I don't think the designated hitter rule is baseball. So maybe that tells you something about my view of how to play the game. I hope that's comment.
Okay, thank you so much. And we are right at 6 o'clock, so I want to make sure that we wrap up on time. But I want to thank each of the panelists so much for joining us at the Law Review Symposium tonight. And thanks to all of you who are out there watching. And I hope that everyone will come back. I believe we have a brief break and then return at 6:15 for the introduction of the keynote speaker, who's the senior senator from Montana, John Tester. And I hope all of you will stick around for that. Thanks again.
Great. Okay.